Thank you for giving me the floor. And at the beginning of my speech, I would like to welcome everyone gathered at our conference, or sorry, sounds better, at our second Polish-Hungarian Scientific Forum, and express that I'm very glad to take part at forum together with you. The topic of my statement is international law and EU law as instruments of interference in the state system. In other words, this is about how external legal norms or instruments of both systems are used or more abused to reshape national constitutional orders. Let me begin with a few words of general introduction in this topic. International law was in the past a set of rules created by states to regulate specific issues. Hence, the first agreements had the character of contracts. If there were any abstract norms serving as rules of conduct, they were found in the international customs. It means in the sphere of unwritten norms, unwritten source of international law. Treaties had created norms to conduct treaties that created norms to conduct emerged quite recently at the turn of the 19th and the 2nd centuries. On the one hand, they codified international customs. On the other, they began to regulate new areas of state cooperation. In this way, international law became a permanent set of norms governing states' mutual relations. A standard of conduct obliged them to behave in a certain manner. Today, international law is no longer a simple canon of rules. International law explicitly prescribes concrete behavior only formally. Instead, international law serves, in fact, as the tool for international actors to justify their action or to compel certain behavior from other entities, at least in the political context. This occurs because the world is changing. The international stage is currently transforming in an objective and unprecedented way. This is not just about the increase of the number of areas of political and social life where state interest and therefore their activities intersect. Today, an objective and unprecedented transformation of the international scene is taking place. And these are not changes qualitatively similar to previous, which took place over centuries. It is no longer about simple changes in borders or alliances. These are transformations of a structural nature, creating a new world. Moreover, the changes are happening at an incredible pace. In the past, to perceive such changes required more than a century. It means one generation of people was unable to notice them in their lifetime. Therefore, for them, the world almost stood still. Today, this happens in less than 1 decade. These changes primarily include, first, the loss by sovereign states of their key role among the subjects of international law and international politics. The centuries-old monopoly on creating international law has slipped from the hands of states. Second, the paradigm of international law has changed. It is not longer solely the state and its sovereignty, but new values such as peace, fight against terrorism, freedom of international trade, climate protection, or human rights. Third, there is certain groundbreaking international events that contribute also to the weakening of international law. For example, it was COVID pandemic or war in the Ukraine, and now this is US intervention in Venezuela, claims regarding US claims regarding Greenland, possibly in the future China's annexion of Taiwan. This is influence of the realpolitik. One of these changes is the growing role of international organizations and various international bodies especially international tribunals. These tribunals are becoming increasingly crucial as they not only settle disputes, but also actively shape or develop the international order through their jurisprudence. They develop legal order autonomously outside the control of states and without restraint. This is in fact often not merely the development of law, but law's actual creation. Using general principles of law and general sounding provisions, tribunals establish concrete norms that they later apply in their adjudication. And states accept this, even though it contradicts the classic national understanding of the rule of law, where there is division and separation. One entity makes the law in democratic procedures, another applies it. Lawmakers is different from law executors. In this way, tribunals weaken the sovereign power of states because creating norms outside states very often interference in states' constitutional competences. There is the question open, would the state have agreed to such a norm in the treaty-making procedure? And in this case, the international legal obligation to execute judgments force states to accept these norms. And at least fortunately, this is done formally by state authorities based on their constitutional and statutory powers. But that gives space, in fact, for state decision. But in fact, it's opened the way for legal conflicts and political abuses. This specificity is abused by undemocratic political forces to carry out action that undermine the rule of law. This is particularly dangerous when the state is governed by politicians who consent to such external action or even seek to exploit the situation to strengthen their own political power. They do not notice or consciously accept or even take advantage of this mechanism to dismantle the state and destroy the constitutional legal order in order to remain the power. This last tendency has recently been evident in Poland, where public authorities have undertaken actions that exceed the boundaries defined by the national constitutional order or more by the legal system as a whole. In the absence of constitutional majority and amid political tensions, there is a tendency to seek legitimacy for such actions in external legal systems, particularly international law and EU law. These actions rely not only on treaties, but just on rulings of international courts. However, and this is crucial, these instruments are often used in a manner that contradicts their actual appropriate legal meaning and legal position in legal order and contradicts the Constitution. What occurs is not only selective application, but also manipulation of the content of international acts, often without a real understanding of their legal nature. In these unlawful practices, Poland's public authorities seek and find external political legitimation. But this mode of operation extends beyond a single state. In debates on Hungary's constitutional system, some participants propose that a future liberal government could use international and EU mechanisms to circumvent the Hungarian constitution to introduce in Hungarian order EU solution and liberal standards. Such arguments reinforce a dangerous trend of treating international and EU law as instruments for generating systemic change outside domestic constitutional frameworks. Given the absence of clear criteria governing the interaction between international and EU law and national constitutional order, it is necessary to explore their impact on domestic law with particular attention to Poland and Hungary, whose constitutional structures differ markedly. This research problem, which is result in a series of publications, with a main element being a book titled International Law and EU Law was as instruments of interference in the state system, was undertaken by the international team of scholars under my scientific supervision. In addition to the book, the project includes scientific articles, blog studies, and conference papers. The project makes it possible not only to reconstruct the systemic foundations of the impact of international and EU law on state system, but also to reveal and investigate the mechanisms thanks which external norms are used or rather abused by national authorities, particularly in context of constitutional conflicts or deficits of political legitimacy. Hence, the research was divided into several stages. The first part discuss theoretically and dogmatic issues. The fundamental task here was to systemize terminology and short clarify key categories and show legal frameworks. On that basis, an analysis was conducted of the relations between different normative orders, national law, international and EU law. In particular, the research considered how EU and international norm enter the constitutional orders of Poland and Hungary, what position they occupy in the hierarchy of sources of law, and on what principles they may influence systemic changes. The key element in this part is to determine the boundaries of acceptable interference of external norms with the internal constitutional order in the substantive, systemic, and procedural dimensions. The study identifies growing collisions between national constitutional orders and EU or international law, which directly impact judicial, legislative, and executive functions. It investigates systemic conflicts and resolution mechanisms, focusing on key rulings from the Court of Justice and the European Court of Human Rights. Special attention is given to case, particularly in Poland after 2023, where national authorities instrumentally use external legal instruments to legitimize action not grounded in domestic constitutional order, or more, to legitimize action against domestic order, even against fundamental principles of that order. This includes selectively invoking or ignoring international rulings to bypass constitutional mechanisms. The analysis was completed by a comparative component aimed at identifying different systemic and constitutional models regulating the relation among international law, EU law, and the constitution in the selected European states. This comparison reveals both the diversity of European approaches to external law and the common mechanisms safeguarding against the misuse of international and EU law to circumvent the constitution, in this way providing essential material for assessing the situation in Poland and Hungary and for defining the limits of influence of international instruments in shaping the state system. The project pursues several specific goals. First, to determine the true constitutional status of international and EU law in the legal systems of Poland and Hungary. Second, to identify the mutual relationships among the Constitution, international law, and EU law, and to analyze their interactions and conflicts. Third, to identify the institutions responsible for protecting the integrity of legal system, both national and international. Fourth, analyze the meaning and practical impact of the jurisprudence of international courts, including their normative character and the character of their implementation and enforcement. The study aims to define the boundaries or permissible external influence on constitutional orders, assessing when such influence aligns with or undermines democratic rule of law. It investigates instances where the limits were crossed, particularly in Poland after 2023, and evaluates Hungary's susceptibility to using EU and international law for internal political purposes. Political purposes. By doing so, the research addresses the scholarly gap and provides a framework to assess the constitutional legitimacy of actions based on external legal sources. The publication consists in 5 chapters. Chapter 1 studies Hungary constitutional system, or Chapter 2 that of Poland, establishing a comparative theoretical foundation. The next 2 chapters shift to institutional practice. Chapters 3 analyze the impact of international and EU law on the functioning of state authorities in Hungary, and Chapter 4 does the same for Poland, focusing on systemic conflicts. The final chapter broadens the perspective with a comparative analysis to selected sorry for being late, to selected European state, providing a wider context for assessing the situation in Poland and Hungary. Overall, the work provides a comprehensive study of the mechanism and limits of external law's influence on the functioning of the state. Thank you for your attention and your patience.